Good morning, everyone. Let's get started. It's so nice to see you all. Welcome to all of those in our streaming audience. For those of you who are not on our mailing list, we would love for you to add your name to our mailing list. There are some clipboards over there with green sheets. If you don't get an email from me on Thursdays right now and would like to, telling you why and what we're going to be doing here in this forum every Sunday, we would love to have you fill that out. We also have an action today having to do with the fact that we jail more people than any other country in the world, an effort to bring that down, looking at the fact that there are a lot of people who make profits off of our increased prison population, and there's an act coming around through Congress we would love for you to endorse and also write a letter to your congressperson and senator about it. We would love to have your financial support for All Saints Church. If you are not a pledging member or a giver, we can solve that problem right this second. All you have to do is go over to that table and fill out a pledge card, and you will be a pledging member, and you will underwrite this amazing experiment in justice and peace and inclusion. We are thrilled you're here. I'm also thrilled at the Holy Spirit and how she schedules our life here in the Rector's Forum. Several weeks ago, we scheduled our speaker for today, knowing that immigration was a hot-button topic in our life, but having no idea that it was going to take on the dimensions that it has taken on just in the last 2 weeks, having to do with terrorism. Obviously, we can sort out refugees and immigrants, and we have exactly the right person to do it. Nevertheless, we've got some fear-based reactivity that can't distinguish and also gets spewed. Its bile gets spewed everywhere. So let me introduce our speaker so that he can start educating us. He's a nationally recognized civil rights attorney. He is the president and general counsel of MALDEF. He'll explain all of that to you. Prior to that, he was counsel to Los Angeles Mayor Antonio Villaraigosa. He served on a 4-person executive team to the mayor, where he provided legal and policy advice on major initiatives. Prior to that, he had conducted civil rights litigation at MALDEF for 12 years, and he was the leader in the successful challenge to California's unconstitutional Proposition 187. He led numerous civil rights cases in the area of immigrants' rights, education, employment, voting rights. He achieved several victories against ordinances unlawfully restricting the rights of day laborers, served as lead counsel in the challenge to California's congressional settlement with Abercrombie and Fitch, on and on and on. He's been recognized on numerous occasions for his work, selected as one of Hispanic Business Magazine's 100 top influentials. He is a graduate of Yale University, summa cum laude, after being born and raised in Southern California, and he received his law degree from Yale Law School. Served as a law clerk to the Honorable Harry L. Hupp of the U.S. District Court for the Central District of California, to the Honorable Stephen Reinhart, one of our heroes here, of the U.S. Court of Appeals for the Ninth Circuit. For 8 years, he taught civil rights litigation as an adjunct lecturer at the University of Southern California Law School, and he's been on many boards. But we love him because he's a great educator at All Saints Church. Will you please warmly welcome Thomas Saenz. Welcome, my friend. Thanks for being back. Always.
Good morning. Thank you, Reverend, for that generous introduction. I was last here 5 years ago, in 2010, and at that time, our country was in the beginnings of what would be dire times with respect to the issues of immigrants' rights in this country. If you recall, 5 years ago, it was right after Arizona had enacted the infamous, now infamous, SB 1070, an attempt to involve every police officer in that state in immigration enforcement, an attempt to drive immigrants out of the state of Arizona by making life extraordinarily difficult for them. Now, at that time, we didn't know, though Arizona was to be followed by 5 other states, I came to call them the dirty half dozen, who also enacted laws designed, in their actual language, they indicated their intent was to drive people from their states and from the United States by making life so difficult for them that they would choose to leave. Now, the good news is, 5 years later, those half-dozen laws have been largely struck down by the court system, including in the 2012 decision by the Supreme Court in Arizona versus United States. And the small remnants of them that remained were ultimately resolved by extremely limiting interpretations by attorneys general in those states to indicate that police could not engage in uncontrolled immigration enforcement, but were very circumscribed in what they could do to enforce those laws. And the good news also, of course, is that this state, California, in introducing me, the Reverend pointed out that I had been involved in arguing against Proposition 187, and this state, California, is in many, many ways a sign of hope for Arizona and for the other 5 states that enacted those laws, that their situations might turn around, and that they too, like California, could become champions of immigrant integration. Because that's in fact what California is today. It's often hard to remember that this month marks 21 years, that's one generation, 21 years, since we enacted by 58% of the vote Proposition 187. Now, that was an initiative that in many ways was even worse than SB 1070. It would have required every person delivering public services from the schools to universities to hospitals to social service agencies to become, in effect, immigration enforcement officers, required to decide if they suspected someone of being undocumented, and if they did, to deny services, to report them, to send them a ridiculous notice saying, we think you're undocumented, so please leave. That's what Proposition 187 was designed to do, only 21 years ago. Now, a generation later, this is a different state. And it's because of folks like the ones in this room and in this congregation that it is a different state, that is much more welcoming of everyone who lives here, much more involved in integrating immigrants into our society. Indeed, I think one marker of how far California has come is that we continue every year to ensure that there are more and more protections for everyone here living peacefully and contributing to our society. I'm proud this year to note that come January, this will be the first state that has incorporated in its basic consumer anti-discrimination law the so-called UNRU Act in California that prohibits business establishments from discriminating against customers. Our law as of January 1st will prohibit discrimination on the basis of citizenship, language, or immigration status, as well as those other isms that have already been blocked. Now, of course, as you all know, so much progress has been made in those 5 years, but we have so much further to go. We see it every day. And I'm not only talking about the congressional inaction with respect to the need for federal immigration reform. I mean, so much of that is characteristic of virtually every public policy issue on which we need our government to act. And it is incapable of acting at the congressional level today to enact what we need. And immigration reform is perhaps the most prominent of the issues that has been on our agenda year after year after year, with ever-present indicators of the need to address the issue, but a Congress that has been unable to do so. But I'm not only talking about that congressional inaction, I'm also talking, as you all know, about our presidential debates. The election season starts earlier and earlier, and even at this early stage of our presidential election process, our least enlightened and least enlightening moments have tended to focus on the issue of immigration and how to address the need for immigration reform. But far beyond that, my concern today and what I want to talk to you about is the way that, unlike that era of SB 1070 and the dirty half dozen, though I will note and talk about another state that more recently, this year, has enacted an anti-immigrant law. Our problem these days is not about those who would directly enact anti-immigrant laws, very clear and open about their intent to make life difficult for immigrants in this country, but about the ways in which nativism, xenophobia has insinuated itself and perverted our discussion of policy issues in other realms, not solely in the realm of immigration. It does start there, but it goes beyond. So let me give several examples of what I'm talking about. One of them is the threat to the administration of a modern government. Now, you haven't heard it talked about this way, but what I'm referring to is the current effort by Texas and 25 other states to prevent the president from exercising prosecutorial discretion by implementing what he announced 1 year and 2 days ago. 1 year and 2 days ago, President Obama announced that he would create deferred action for children, for parents of Americans, a program to provide legal protections from deportation, employment authorization to certain undocumented immigrants who had been present in the country and were raising children, including United States citizen children, in this country. He also announced an expansion of DACA, Deferred Action for Childhood Arrivals, a program that at that point had been in place for 2 years and had provided relief and protection and work authorization to thousands and thousands of immigrants who had come to this country without legal protections as minors. Now, you may recall that the reaction to the president's announcement of DAPA and an expansion of DACA was extremely politicized, to use a polite term. And it resulted in a misuse of our court system by the state of Texas and others who challenged the president's authority to exercise his undoubted right of prosecutorial discretion in the way that he did. To be clear, the president's ability and authority to decide how to enforce laws, including immigration laws, is quite clear and acknowledged by everyone, in part because so many of those who would target and attack what the president has announced themselves one day would like to be president with that authority. So everyone will acknowledge that a president has discretion. What is at issue in Texas versus United States, which, as you all may know, is about to go to the United States Supreme Court for ultimate resolution. The issue is how a president can exercise that prosecutorial discretion. Now, in a modern age, in the 21st century, with so many people involved, not just the immigrants involved, but also the day-to-day rank-and-file officers in the Department of Homeland Security, there seems no other way for a president to exercise meaningful prosecutorial discretion than providing the kind of guidance to lead officers in the Department of Homeland Security to make correct decisions, decisions in line with the president's discretion. There seems no other way of doing that than by doing precisely what the president has already done with DACA and intended to do with DAPA and the expansion of DACA. That is, give clear guidance to those making decisions about who should be granted deferred action and provided with protection from deportation, making clear his views as president as to whom should be allowed to remain for the present, while we focus instead on enforcement priorities identified at the federal level, ultimately by the president himself. So instead of seeing Texas versus United States as purely an act of political theater, it is certainly that. As purely an act of anti-immigrant policymaking, it is clearly an attempt at that. We should also see it as a threat to how any president can exercise his or her authority in a modern age. You simply have to be able to nimbly put in place guidance, written guidance, even enforced written guidance, to the rank-and-file employees making decisions day to day. But Texas versus United States basically contends that the president has no ability to do that, a real threat to administering a modern state. Of course, you all know intimately how more recently xenophobia and nativism have invaded our discussion about humanitarian refugee policy. Now, often there are attempts to separate humanitarian refugee policy from the rest of immigration policy. In this case, that clearly has not worked. as too many governors and other leaders have indicated their intent to bar the door to refugees seeking relief from dire conditions in the Middle East and elsewhere. Now, this is not new. I remind us that it's just a little over a year ago that we saw almost ubiquitous overreaction to the phenomenon of unaccompanied youth from Central America, also fleeing very dire conditions for their lives and their safety, to reunite with family away from danger. And the reaction then, even just down the street in Murrieta, California, was for folks to block buses. In Texas, city after city passed resolutions barring those Central American refugees from entering their bounds. So we've seen this a little more than a year ago, and today we are allowing this anti-immigrant politics to invade the humanitarian issue of welcoming refugees fleeing the most dire of conditions. We have also seen in recent months how law enforcement itself, policy about law enforcement, has been perverted by anti-immigrant politics. I give you the example, and it was never discussed quite accurately, in my view, of this anti-quote-unquote sanctuary city movement that we have seen across the country. Much of it catalyzed by the tragic murder of Catherine Steinle in San Francisco. The reaction to that tragedy, too many political leaders calling for anti-immigrant policies, greater cooperation between local law enforcement, completely untrained local law enforcement, with immigration forces. What we saw was a failure to apply what we already know about criminal law, what we already know about criminal justice policy. Now, I will be the first to admit that in other realms of criminal justice and criminal law, we're not always a rational people when it comes to debating these policy issues. But in this particular regard, there was absolutely no concern or consideration in even the most cursory of ways about how criminal justice policy might lead us to react to the Steinle tragedy, might lead us to adopt policies about using removal, deportation in the criminal justice arena. Let me explain. There are generally 5 acknowledged purposes for criminal punishment. If we were to review each of those 5 and apply them to the use of deportation, removal from this country, as a punishment for criminals, it would fail. Those 5 are incapacitation, deterrence, rehabilitation, restitution, and retribution. But if any political leader had bothered to look at those and compare them to what we learned from the Steinle tragedy, we would not be moving in the direction that we have been moving at the federal, state, and local level. For here is where the most recent state to enact an anti-immigrant law chose to act. A few weeks ago, North Carolina's governor signed a law entirely in response to this anti-sanctuary city movement, whose effects would be much broader than simply mandating, as it does, cooperation between local law enforcement, regardless of the views and policies of local government, with federal immigration. But looking again at those 5 purposes for criminal justice, incapacitation. We imprison criminals sometimes to prevent them from being able to offend again during the time that they are in prison. But if the facts that were reported are true about the individual who murdered Catherine Steinle, then we know that removal from this country does not incapacitate anyone. There was so much overreaction to the fact that that individual had come back to the country 5 times after being removed, as though that somehow meant we should strengthen our use of deportation and removal in criminal schemes, instead of telling us what it does, which is removal from this country does not incapacitate anybody, even when the border is more well patrolled, more enforced than it ever has been in the history of this nation. Deterrence. Do we really believe that removal from this country is a deterrent for anyone to commit a crime? How can it be so when so many peaceful, law-abiding, immigrants without legal status daily face a threat of deportation, not because they've done anything in the criminal law arena, but simply because of their status here. When we have policies that regularly remove people who have committed no crime, how can it be a deterrent to committing crime to say if you commit a crime, you may be deported or removed from this country? It can't be a deterrent when that's a ubiquitous threat for millions and millions of people in this country. Rehabilitation. I don't think there's any indication, nor could anyone argue, that being removed from this country contributes to rehabilitation of anyone who has engaged in a criminal act. There simply is no basis for believing that that process would rehabilitate anyone. Now, we have our own challenges here, as we all know, with rehabilitation in our criminal justice system. But I guarantee you there's no greater rehabilitation when someone is summarily deported and removed to their country of origin. Now, restitution, clearly, removal has nothing to do with that. That leaves us with retribution. Perhaps the least well-supported of reasons for criminal justice punishment among the five. Is there some retributive effect of removing a criminal? Perhaps. Perhaps the victims feel better knowing that the person was deported, but I'm not certain that that would be the case when we see, as we did with the Steinle perpetrator, that they're able to come back to this country even with a well-defended, a well-enforced border. So if we look at what we traditionally would look at in criminal justice, we know now that deportation ought not be a tool of criminal justice in any circumstances. It serves none of the interests of criminal justice that have been identified historically and continually in this country and without. But we have allowed anti-immigrant sentiment, xenophobia, to infect our assessment of this criminal justice policy so that even the most progressive of leaders today will openly argue that there are exceptions, that certain folks should be deported and removed, instead of understanding that from the perspective of policy, using deportation and removal in any way related to criminal justice makes no sense. And I want to conclude by perhaps the worst and most concerning way in which anti-immigrant sentiment is beginning to infect our policy in other ways. This relates to a case that will be decided by the United States Supreme Court this year, that will be argued in a little over 2 weeks before that body. It's a case that you may or may not have heard of, and I want you all to leave the room understanding how much of a threat this case is. The case is named Evenwell versus Abbott. Now, you may hear it referred to as Evenwell. That may be actually the pronunciation of Sue Evenwell, the plaintiff's name. But I have vowed never to pronounce it as Evenwell because, as you will hear, there's nothing even about what I'm going to describe in this case. Evenwell versus Abbott is the third test case funded by right-wing forces to attempt to change how every one of us in this room and beyond votes. The contention in Evenwell versus Abbott is that our electoral districts, from local city councils, school boards, county boards of supervisors, up to the state legislature and congressional, should be drawn based on voter population rather than total population. For many, many decades, the Supreme Court has dictated appropriately that electoral districts should be roughly equal in population after each decennial census. Based on that requirement, every state across this country has equalized state senate districts, state house districts, congressional districts, school board seats, based on total population. The Evenwell plaintiffs contend that that is unconstitutional, and that instead districts should be equalized based on voter population. Now, what's behind that? Who gets disenfranchised? Not really disenfranchised, but rather discounted entirely if the Evenwell plaintiffs are to prevail. Clearly, who they are targeting are immigrants, not yet naturalized and therefore ineligible to vote. The collateral damage is every child under the age of 18 would be completely discounted for purposes of drawing these electoral districts if the Evenwell plaintiffs were to prevail. It is perhaps the most extreme manifestation of how attempts to exploit anti-immigrant sentiment has insinuated itself and affected our political decision-making in other realms. Now, what is one of many ironies in the Evanwell versus Abbott case is that Abbott, the defendant, our champion, if you will, in the United States Supreme Court on this issue, is none other than Governor Abbott of Texas, the self-same Governor Abbott who is leading the fight in Texas versus United States against the just use of executive authority by President Obama. But he is our champion in the Supreme Court. Now, as an aside, I'll say, fortunately, the United States Solicitor General has requested 10 minutes to argue in front of the court, and he will be granted that ability, so we'll have more than the voice of Texas heard before the Supreme Court. But related to that irony of Texas being the champion of total population-based districts is that Texas's view on this is a states' rights view. So the state of Texas will not argue that it is a constitutional requirement to use total population, as every state has to date. But Texas will argue that every state should have the discretion to decide on its own whether to use total population or some measure of voter population. Now, I believe that the Evanwell plaintiffs expect to lose, but what they are seeking is exactly what Texas will urge: a clear decision from the Supreme Court that says each state has the option and the right to decide for itself whether to equalize its electoral districts based on total population or voter population. What will then occur, as you all can predict, are well-funded campaigns in the states viewed as most vulnerable to anti-immigrant sentiment, driving them to move from the ubiquitous use of total population to voter population, to discount entirely immigrants and, of course, children. Now, the final irony of all of this, and one I want you to walk out of here to share with everyone, and to share your views publicly about every constituent counting, about our keeping total population as the basis for drawing districts. But the ultimate irony is this: the plaintiffs in Evanwell ground their case on the 14th Amendment. Now, for those who may not recall, the 14th Amendment, among the many things that it did, including establishing equal protection and due process across the nation, including making sure that there would not be discrimination on the basis of race following the Civil War, it also eliminated the so-called 3/5 compromise that was a part of our original Constitution. For those who recall from their civics courses, and I see nodding heads, that compromise included an abomination in our Constitution that indicated that certain persons, namely African American slaves, would only count as 3/5 of a human being for purposes of allocating seats in the House of Representatives among the different states. Now, the 14th Amendment eliminated that and made quite clear that total population must be used in allocating seats in the House of Representatives among the states. But the Evanwell plaintiffs argue that the self-same amendment that eliminated the 3/5 rule in allocating seats among the states requires every state within its boundaries to then discount immigrants and children entirely in drawing the districts. So you may get your congressional seats based on total population, but you then got to draw those districts based on voter population. In essence, what they are arguing is that the amendment that eliminated the 3/5 rule imposed a 0/5 rule for immigrants and children. Now, this has not received much media attention. It is a looming danger that could set this country back decades in our efforts to ensure that we live up to the principles of our Constitution. And it is an instance in which anti-immigrant sentiment, xenophobia, there is no coincidence that the case was brought in Texas. Xenophobia, nativism, begins to infect how we decide on our electoral districts as well as those other policy areas that I've described. Now, it is my hope and belief that regardless of what the Supreme Court decides, that we will, as a people, rise up when the issue is presented, if it is presented state by state, and make clear that we will not allow anti-immigrant sentiment to pollute our electoral representation, that we will not allow a dehumanizing of immigrants to become written into law in how we draw our electoral districts, that we will resoundingly say that every constituent counts. Every constituent counts, whether voter or immigrant or child in this country, and that we will not tolerate a zero-fifths rule in the 21st century United States of America. Thank you.
I'm going to pose the first question. Do we have microphone handlers ready to go? Great. Please raise your hand on this side if you want a microphone. Raise your hand on this side if you want a microphone, and be ready. I want to pose the first question. So, Thomas, give us some insight into why the Supreme Court even accepted this case.
I wish I had such insight. It was a surprise to all of us who had been following the case. MALDEF had attempted to intervene in the litigation as we had successfully intervened in its predecessor. This is the third case that these folks have tried to bring to the U.S. Supreme Court. This one's in a slightly different posture in that it goes directly from the district court, the trial court, to the U.S. Supreme Court, bypassing the Circuit Court of Appeals. But no one knows or understands why they took the case. There are some, including myself, who hope it might be to stop these test cases by making clear that total population, which is used ubiquitously, is what should be used. But the looming danger is really that the states' rights perspective prevails, and we end up with these battles in Texas, in Arizona, North Carolina, Kansas. We could pick out the states where they're likely to target those that they view as most anti-immigrant in sentiment.
And are there other states who've joined the case?
So there have been amicus briefs that have been filed by a number, friend of the court briefs filed by a number of organizations. That includes states that are on the side of using total population. None have yet emerged on the other side. There are spokespeople, and you can readily discern, and I could explain what is where this case emanates from. But what we have seen is, by and large, states understand how difficult, just as a practical matter, using something other than total population would be in drawing electoral districts. The plaintiffs have not been clear about what they want to be used. It could be citizen voting age population, which includes some non-voters, but is an estimate provided by the census on a every 3 years basis. But they could use voter registration. They could use voter turnout. And we all know that voter registration changes daily, in part because of the efforts of folks in this room and beyond who want it to change daily. Voter turnout changes election by election. Imagine the practical nightmare of having to draw districts on something other than total population, and you understand why most states are in favor of continuing to do what they do.
There's a question right behind you. Paul, let me ask one more question. And you can wait until the closing when we have the invitation to come down and join. I want you to talk about MALDEF. So why don't we let that be the closing? Please, question. Keep talking. No, keep talking. It's on, right?
Thank you, Mr. Thomas Saenz. This is an opportune moment for me, and I thank Pastor Ed for introducing your background and your works. I am an immigrant, as you can hear from my accent, but I'm a legal immigrant. When I left my country, way in Southeast Asia, I had the visa to carry. The American embassy gave it to me and said, do not put it in your trunk, hand carry it, because as soon as I came to LAX, they separated me. But I'm also a thinking person. I'm a Christian. So I voted yes for Prop 187, and as you said, it passed. I could never understand how it could be overturned. I knew not why would it be on the ballot. It passed, and it turned. The way I understand it, Proposition 187 says that if you're illegal, you do not get services from the government paid. They come here at their own risk, is my opinion. Because when I left there, America is so attractive. One of my colleagues said, Pete, can I come with you? I'll go illegal. They are willing to take the risks at their own risks. And I do not understand until today the logic that Proposition 187 is unconstitutional. Convince me.
Sure.
Because
So let me explain. The question is why Proposition 187 is unconstitutional. It is unconstitutional, as were large parts of SB 1070, because our country can only have one immigration policy. We cannot have 50. Each state does not get to have its own immigration policy. And in so many ways, what California sought to do in 187, as Arizona sought to do in SB 1070, was enact its own immigration regulatory scheme. That is unconstitutional because our Constitution allows but one immigration regulatory scheme in the nation. I think your characterization of 187 is slightly inaccurate. It was not only about denying services, which are already denied by and large, with a few exceptions, including school, kindergarten through 12th grade for children. But what it would have done is required folks to engage in arriving at their suspicions, language used in the law about specific people. And unfortunately, we know what suspicions on immigration status usually rely upon. Its race, its language, its accent, its appearance, you name it. It leads to widespread discrimination. And every person, regardless of status, because we do not have the ability to look at someone and know that's citizen, that's not a citizen, every person would have been subjected to that suspicion. And suspicion alone would have led to denial of services. I have one more comment, which is this. I think it's terrific that you were able to come with a legal immigrant visa, but there are so many problems with our existing system, and I want to cite one of them. And that is, and any one of you can get this bulletin by subscribing at the Department of State website, but we have an immigration system that decides when you are allowed to immigrate based not only on your relationship to someone here or your labor skills, but also on the country that you come from. So that waits from countries that have a larger demand to immigrate are much, much longer, which means, for example, that for certain categories of legal immigrant, a person from anywhere in the world will wait 2 to 4 years. But if you are from Mexico, which has the greatest demand to immigrate, despite what we've seen in the paper today, the greatest demand to immigrate, if you have the exact same relationship to someone in this country as that person from anywhere in the world, you will wait 12 to 14 years or longer to get your visa, at least 10 years longer. So many folks, understandably in my view, faced with the prospect of waiting over a decade, longer than others, to reunite with family members, choose to come without status because they're not willing to wait that 10 years. And I emphasize this because the next time any one of you hears a political leader say that folks should get in line, you should respond to them, whether or not they're able to respond back, that there is no one line. It's different lines, and the line depends on what country you come from. And in a country like ours that values equal protection and anti-discrimination, that's part of what needs to change in comprehensive immigration reform.
All the more reason we need comprehensive immigration reform. Thanks for your words, Tom. I want to ask you to circle back to the issue of Texas v. U.S. and the challenge to the DAPA and DACA programs. No doubt it's going to have an influence on next year's elections. Can you speak to the timing of that, the case, and I guess your own analysis of how you think the court ultimately will decide?
That's a good question, Dennis. You know, the timing is unknown at this point, in large part because, as I'm sure some of you read, there are concerns about why the Fifth Circuit took so long to reach a decision that it seemed obvious that panel would reach. But the timing is such that we are uncertain whether it will be heard or can be heard by the U.S. Supreme Court in this term. As you know, that means if it can't be heard this term, the earliest it will be heard is next fall, and the earliest it could be decided would be after the next presidential election. So there is at present an attempt to ensure that things are expedited so the Supreme Court can hear and decide the case this term, meaning issuing a decision before June 2016. One of the hopeful elements, admittedly a minor hopeful element out of the Fifth Circuit, is that MALDEF's clients were allowed to intervene in the case. We had been denied by Judge Hainan, who had also issued the initial preliminary injunction blocking DAPA and expanded DACA, but the Fifth Circuit agreed that he was wrong in that regard, and our clients, who are 3 potential beneficiaries of DAPA, have now been intervened in the case. We will participate in the case at the Supreme Court as full parties. We are working with the federal government to try to expedite the decision, the briefing, and the decision about whether to hear the case so that we can get a decision before June 2016.
Very quick last question.
Yes. We have so many folks that are talking so ill about Latino Americans, specifically Mexican Americans, and we have the media jump all over that and give that a lot of time on network television, on cable, the cable networks. And I'm not going to name anyone specifically, but we have very little focus from the media talking about what you're describing today about immigration. And how do we change that dialogue in America? How do we get fair and balanced media on this issue?
Well, that's a whole nother speech, as you know, David Damien, but, and I don't think that there's an easy solution. I mean, we do live in an age when media is much more broadly defined and broadly available than it used to be, so I am hopeful that through things like live streaming of this and other forums like this, that folks begin to get exposed to different points of view than they ordinarily receive. But it really is a matter of our acting as consumers to put pressure, as you know, on those who make those decisions to have some greater balance and to ensure that they are not only reacting at individual periods of time when someone may say something particularly beyond the pale, but really on an ongoing basis looking for ensuring that voices across the spectrum, including voices that are more consistent, in my view, with the principles of this country, are heard and presented on network television and beyond.
MALDEF.
Thank you. MALDEF is Mexican American Legal Defense and Educational Fund. We are getting close to our 50th anniversary. We were founded in 1968 in San Antonio, Texas. We are now a national civil rights legal organization. We do our work through the legal system in both court cases and public policy advocacy, as well as community education and communications to promote the civil rights of all Latinos living in the United States. The Mexican American Legal Defense and Educational Fund is a element of our history. We serve the entire Latino community, and our goal is to accomplish that protection and promotion of civil rights in the areas of education, employment, immigrant rights, and voting rights. And we do it through a network of offices, including our headquarters in Los Angeles, where we're an office where we were founded in San Antonio, one in Chicago, and one in Washington, D.C. We work in coalition regularly with other civil rights organizations attempting to arrive at policies in those areas and beyond that better reflect the constitutional principles of this nation.
Thank you, Tom.